Hi, everybody. Good afternoon. Thank you so much for joining us today to discuss the threats facing administrative law enforcement and what they mean for workers and consumers. My name is Suzanne Kahn. I'm the vice president of the think tank here at the Roosevelt Institute. The Roosevelt Institute, for those of you who don't know, is a think tank, a student network, and a nonprofit partner to the FDR Presidential Library and Museum. Together, we learn from the past and are working to redefine the future of the American economy. As many of us on this call are aware, we are living through an era of corporate and conservative backlash to a National Labor Relations Board that has used its legal authority to protect workers by enforcing important labor protections. Several major corporations like SpaceX, Starbucks, Amazon, and Trader Joe's, in an attempt to degrade worker power, are undertaking the underlying constitutionality of the NLRB. These attacks are troubling at any time, but they are especially threatening given the ideological makeup and recent decisions of the current Supreme Court. Over the past few years, the court has signaled a willingness to claw back the powers of the administrative state, and it appears poised to continue doing so in its upcoming term. So today, to discuss this, I'm thrilled that we are joined by a great series of panelists and the General Counsel of the National Labor Relations Board, Jennifer Abruzzo. General Counsel Abruzzo's appointment in 2021 followed her more than 20 years of experience at the NLRB in various roles, ranging from field attorney to deputy general counsel. From the moment she took the reins to lead the NLRB's enforcement activities, GC Abruzzo has made it clear that the agency is charged with enforcing a statute that is pro-worker. In fact, her first memo directed staff to consider cases that could be used to ask the board to reverse legal precedent that doesn't comport with the agency's mission, including cases that make it more difficult for workers to unionize should they want to do so. Under her leadership, she has issued legal guidance seeking to protect immigrant workers from employer retaliation and to apply organizing rights to college athletes. She has pushed for more robust remedies for labor law violations, including full relief for victims of unfair labor practices. She has also dusted off underused legal tools in an effort to get workers promptly reinstated to their jobs after unlawful firings, including by seeking injunctions against high-profile employers in order to stop violative conduct aimed at chilling organizing activities. GC Abruzzo's NLRB has embodied the National Labor Relations Act's assertion that it is the policy of the United States to encourage collective bargaining. We're excited to hear from her to provide some framing remarks, and then we'll hear from an excellent panel of Roosevelt Fellows and Partners. General Counsel Abruzzo, thank you so much for being here today.
Thanks so much, Suzanne. It's great to be here. I really appreciate the invite. So I just wanted to, I typically do this and I'm going to continue to do it here, but I just want to start with first principles and put things into context. And that is, the NLRA was enacted almost 90 years ago now. And it was enacted as an attempt to equalize bargaining power at the workplace between employers and their employees and representatives. And our statutes govern labor relations ever since. And what's super important, I think, for the discussion that will be had today is that it is the only federal labor law in the country. And the NLRB is the only federal agency that protects the rights of workers to engage in union and protected concerted activity. And let's just keep in mind that, there's no private right of action, unlike other worker protection statutes, where, employees can seek redress in court. So what that means is we're the only show in town when it comes to obtaining remedies for violations of federal rights under our statute. And I always keep that in the forefront of my mind. I can tell you that there is no way, despite, our very limited resources and our board agents being overwhelmed with quite a number of cases, but there is no way that we're going to succumb to the pressures imposed in addressing these challenges and in defending the constitutionality of our agency structure. So for us at the agency, particularly those that have been around for a while, it's deja vu all over again. But this time around, let's keep in mind these esoteric legal arguments came about. Why? because we dared to issue a complaint against SpaceX after it unlawfully fired 8 workers for speaking up about their workplace concerns. And then, you know, as was noted, like Amazon jumps on the bandwagon, Starbucks jumps on the bandwagon, Trader Joe's, others get into the action just because we are trying to hold them accountable for repeatedly violating workers' rights to organize and collectively bargain through representatives of their free choosing. And, you know, it seems like a growing number of deep pocket, low road employers are jumping on the bandwagon, seeking preliminary injunctions in the courts solely to slow down or prevent us from engaging in our enforcement actions against them because they have the money to do so. And unfortunately, it seems to me they'd rather spend their money initiating court litigation rather than improving their workers' lives and their own workplace operations. So their primary goal, in my mind, is to divert our scarce resources away from protecting workers' rights to organize and to fight for recognition and respect for the value that they add to their employer's operation. And that is not going to happen. We're not going to postpone or cease our investigations or litigation or our compliance or election work while we await the courts to presumably resoundingly reject, once again, the long rejected challenges that have been lodged against us. So I'm just going to talk briefly about, you know, some of the challenges and that we faced and what we're arguing. But so one is the removal protections of the ALJs and the board members. And aside from the fact that any potential offensive language in the statute could be severed, you know, the decisions of ALJs can't bind the agency. The ALJs have no enforcement or policy-making authority. So, you know, in our mind, it distinguishes it from Jarchese, or distinguishes them from Jarchese. And as to the removal protections of the board members, you know, there's case law, Humphrey's executor for one, that says that, you know, a multi-member body of experts who are balanced along partisan lines, that are appointed to staggered terms and, you know, perform quasi-judicial and legislative functions is perfectly okay. So as to another argument, which is the 7th Amendment right to jury trial argument, you know, as many of you likely know, the Supreme Court has already weighed in on this over 80 years ago in NLRB versus Jones and Laughlin. Decided that the right to a jury trial does not extend to cases under the NLRA because we enforce public rights, specifically prohibitions against interference with employees' union and concerted protected activities. And also the relief that we seek, the monetary relief, because we can't seek punitive relief, is often intertwined with reinstatement such that the 7th Amendment would not even be implicated. And the board's most recent decision in Thrive, which actually utilizes Section 7 of the statute even more in terms of make-whole remedies, is still incident to equitable relief. So we think we've got real strong arguments there. As to due process arguments, you know, just because there's a combination of prosecutorial and adjudicatory functions in a single agency does not violate due process. And unfortunately, board decisions are not self-enforcing. So, you know, court review is certainly available for any aggrieved party. And then the final sort of challenge was as to the actions of board members in authorizing injunctive relief under Section 10J. But, you know, the courts have been clear that that structure does not demonstrate prejudgment bias. And frankly, you know, that issue can easily be disposed of by delegating the responsibility for initiating Section 10J proceedings to me, the General Counsel. We also talked through the balance of equities and public interest factors. And I will just say, as you all know, I mean, this is just common sense that allowing a preliminary injunction to move forward in these sorts of cases would encourage parties unhappy with our merit decisions to go to court, and they would try to stop our proceedings. Also, this sort of preliminary injunction would significantly interfere with the only agency that enforces the only statute involving labor law, a statute that was enacted by representatives of the people. And so that is, to us, courts engaged in stopping are enforcement actions pursuant to a statute that was enacted by Congress is irreparable public harm. There's, there's more arguments that we've made in many pleadings. I would commend you to check out the response to the PI that we filed in the Southern District of Texas in opposition to SpaceX's motion for a PI. We filed that in February. But I will say, getting back to what I was saying, we are not going to stop despite these challenges. We issued another complaint against SpaceX related to unlawful severance agreements. We continue to litigate against others like Starbucks. We just obtained an order from the DC Circuit finding that it violated the act by prohibiting distribution of union paraphernalia at any time in a store. We just got a board order granting a motion for summary judgment against Amazon regarding its promulgation of an unlawful rule regulating access to its facilities by its off-duty employees. And I just want to note one other thing before, the esteemed panel, which I'm really looking forward to hearing from, begins. But, I talked about the primary goal, and I think that that's right, that they're just trying to have, cease us from engaging in enforcement action or cease our engagement. But there's also this secondary goal, I think, which is to divert attention away from the fact that they are actually lawbreakers who need to be held accountable in a timely manner. And frankly, that strategy is working. There's a lot of public reporting about the challenges as opposed to the lawbreaking. So, I think we all just need to keep that in mind. But at the end of the day, as I recently said at a few ABA conferences to an audience of really bright and tenacious and long tenured labor and employment lawyers, that just because you could make challenges and arguments does not mean you should. And it doesn't mean that it's in the best interest of your client. My pitch was that their client should be respecting workers' choices, listening to their workers' voices, addressing their workers' concerns, as that's going to diminish workplace conflict, and that will be beneficial to everybody, the workers, families, communities, operations. So, I'll end with what our congressional mandate is, and that is to encourage peaceful resolution of industrial disputes. And that depends on an effective means to vindicate public rights. It means we have to be able to operate. And frankly, even some who focus on employer interests have publicly said that there would be chaos at the workplace without a functioning NLRB. And I completely agree with that. So I'll stop and turn it back over to Suzanne and the panel.
Great. Thank you so much, General Counsel Abruzzo. My name is Ali Bustamante, and I'm the Deputy Director of the Worker Power and Economic Security Program at the Roosevelt Institute. And it's my great honor and pleasure to introduce to the panel today that will be discussing some of General Counsel Abruzzo's remarks. First, we have Hiba Hafiz. She is an assistant professor of law at Boston College Law School. She researches and writes in the area of labor and employment law, antitrust law, and administrative law. Her research focuses on legal and regulatory solutions to labor market concentration, employer buyer power, and broader labor market failures, as well as improving the institutional design of labor market regulation in the administrative state. We also have Sabeel Rahman, who is a professor of law at Cornell Law School. He is also a co-founder and faculty co-chair of the Law and Political Economy Project. His academic research focuses on issues of democracy, governance, economic power, and political economy paradigms, as well as racial equity and inequality. He works extensively with a range of think tanks, advocacy organizations, and foundations to develop novel approaches to addressing these issues in practice. And lastly, but certainly not least, we also have Diana Reddy, who joined UC Berkeley School of Law as an assistant professor in last year. She teaches contracts, courses in labor and employment, as well as seminars on organized labor and civil rights, law and political economy, and social movement advocacy. Diana's research focuses on the regulation of work, as a site where critical choices are made about the relationship between American economic commitments and its democratic ideals. So thank you all for joining me. And I'm really looking forward to just jumping in. We just heard, these remarks from NLRB General Counsel Abruzzo about the ongoing corporate attacks on the NLRB. And I was really taken by the fact that these attacks are being made by lawbreakers. And so, Hiba, I actually wanted to start with you, if you don't mind. I would love for you to talk us through the implications of these recent challenges for labor relations and workers' rights in the United States.
Okay, great. Thank you so much. I'm so excited to be here. And I'm really excited to join this team of folks in talking about these challenges to the NLRB's authority and ability to impact worker power. I think, we're going to get into some of the constitutional challenges and their merits in a minute. So I'll focus for now on what I think the kind of real implications of these challenges are in terms of labor relations and workers' rights as they're unfolding in current organizing campaigns. So of course, right, challenges to the administrative state can be more deeply harmful for those who get government benefits, for those who are the most vulnerable among us, and for those who are protected by rights that are, in general, more likely to be violated by folks with significant amounts of economic or political power. And so challenges to the administrative state are always going to be kind of red flags and alerts for whether or not we are sufficiently protecting fundamental rights and liberties to access economic opportunity through the political process by passing legislation that agencies can enforce. So that's already a concern, and I think something that should be the subject of political debate in our conversations about what these challenges mean. And we'll get into what their likely effects might be in the courts. But I think from the perspective of the effects on the labor movement, General Counsel Abruzzo already highlighted ways that this has allowed firms to shift the debate from a focus on their violations to a focus on the nature of these constitutional challenges and what the role of the courts are in regulating the administrative state more broadly. But just some of the things that I wanted to highlight too are the fact that that it's not just the usual suspects that joined in on these challenges, that it's also nonprofit organizations like the ACLU that are facing unionizing campaigns. So this is an equal opportunity set of challenges that we, within as a community on the left should be thinking through where we situate ourselves in protecting, rights that are enacted by Congress through the democratic process for workers who are facing employers that are trying to bust their unions, which include, expressive and associational rights. So that's an issue. But it's also the strategies that they're using that I think are useful to highlight. So the tactic of SpaceX, for example, to try to transfer the case from Texas to California, to try to, to prevent the Ninth Circuit from, say, the Fifth Circuit from making important decisions about what the future of the administrative state could be. That's not only a delay tactic, but also is a form of forum shopping and taking advantage of a trend in the courts to override judicial precedent, the long line of which General Counsel Abruzzo cited. But this kind of holding pattern that we're seeing is somewhat familiar, and I think Diana will get into this a little bit, right, from the history of workers' rights in the NYRA and in the National Labor Relations Act and employers' noncompliance and constitutional challenges to congressional authority to regulate workers' collective rights. And so in addition to being a distraction, it's also a significant delay tactic by firms that are obviously facing some of the most significant and high-profile union challenges that could set precedent more broadly for workers' ability to organize, and also in interesting ways, workers' ability to design collective bargaining agreements and collective bargaining structures, including national structures, that could enable workers in the service sector and more broadly areas of growing union density to think through what their strategies could be as a model. So we're seeing these effects as being significant in the context of Amazon, Trader Joe's, contributing to the high costs of trying to build a union campaign from the ground up against really dominant firms, creating divisions among unionized workers, delaying the process from electing a union majority to getting to the first collective bargaining agreement. But on the other hand, we do have the counterexample of Starbucks as kind of a counter narrative to these more standard stories. We know obviously that Starbucks has spent over like nearly $250 million on its anti-union campaign. But Workers United have finally begun negotiations to really secure a foundational framework for a collective bargaining agreement or a master contract for nearly 400 stores that they've unionized. Despite and this is in part because the NLRB, because the General Counsel has been successfully prosecuting unfair labor practices over 700 ULPs. So this may be a case where truly the strength of the organizing can override many of the legal challenges, but it really depends on the strength of the organizing. Most workers don't find themselves in this spot.
Yeah, thank you so much for that. And as you mentioned, attacks of this nature are not necessarily new. And I think it's worth understanding the historical context that these recent attacks are in. Diana, if I can go to you for a moment, why is this happening now? And what, if anything, has changed since the NLRB was created all the way back in 1935 and since the Supreme Court upheld its constitutionality in 1937?
Great question. Just again, hi everyone. I am thrilled to be here. When I was taking Econ 1 at Stanford University with John Taylor back in 2000 something, I never would have expected to have this kind of forum and to be a part of it. So I'm thrilled. I'm really honored to be here and really grateful for the folks who are attending. It's a great question. What can history tell us about where we are today? I mean, I'll start with the fact that this isn't new. When the NLRA was enacted, employers fought tooth and nail to have the court find it unconstitutional, and they generally refused to comply with it for 2 years. Until the Supreme Court weighed in on its constitutionality in a way that, I mean, at the time was unexpected. The left expected to lose in front of the Supreme Court then, but I think it's really important to point out that in part because this legislative innovation, the administrative law innovation, was coupled with real organizing and protest on the ground by workers. That did not happen. So I think that's a really important part of the story, right? This isn't just a triumph of formal law that we've had this incredible law for so long. It's also a triumph of worker engagement and kind of more direct democracy. That said, I've written about the extent, I focus on the relationship between law and organizing, law and culture, law and public opinion. There have always been limitations in American labor law. There are real challenges to making it effective for the workers it's intended to protect. Those were present mid-century. But I think the question of, was labor law administrable through an effective agency, those questions were made easier by the fact of high union density, of really high public support for labor unions, such that for a while, many employers were at least restrained by that kind of countervailing power from making these kind of foundational attacks. It was just, many big employers, many of the biggest employers with access to the, most powerful law firms had ongoing collective bargaining relationships. Not all of them, certainly. But, this kind of bare knuckles, let's throw the whole thing out. There would have been really massive opposition. And so for a while, I mean, there's, there's a lot of debate about whether we ever had, a detente between labor and capital in this country, but certainly, mid-century, we're looking at something of a somewhat different quality than what we have today. As to what's happening now, why is this happening right now? I think General Counsel Abruzzo stated it really well. Because they dared to issue a complaint against SpaceX. The lawsuit was filed a day after I think the board consolidated the cases and set a hearing date, and just a few weeks after the complaint was actually filed. The current NLRB is just incredible. They are just absolutely incredible. As someone who's been studying labor law for a long time, and who, when I was studying it, the general consensus was, and forgive me, to kind of the incredible NLRB employees who were fighting the good fight this whole time against, in a really different political context. But, I'm looking at an article from 2009. The NLRB is without any influence in the shaping of national labor policy. It has a seeming inability to be proactive in responding to massive changes in the economy and labor relations. I don't think anyone could say that today. No one could say that. And again, I think, again, administrative law, any form of law, it does not occur in a silo. It occurs in a broader political, economic context. So I think, today, what the NLRB is doing is certainly about administrative law brilliance, but it's also about kind of changed political realities, changed consciousness, changed levels of worker agitation. So the NLRB is incredible. It has done incredible things in the past several years. I'm really kind of challenging the consensus, the legal consensus before, which was that, labor law was just ossified and nothing could be done until Congress acted. And, Congress was never going to act, it seemed like. And so there was just nothing that could be done. And under General Counsel Abruzzo, it's really incredible expert governance. And, and that's landed really well for us. How has that landed for, those who aren't as supportive of the mission of federal labor law? I was listening to an administrative law podcast, Gray Matters. It's hosted by conservatives out of the Antonin Scalia Law School. And one of the commentators there, I think in a really self-aware way, said, listen, administrative law is supposed to be boring, and they made it non-boring, right? And then he said, probably my friends on the left would say it was never boring, and it always had to do with, it was always making really important decisions. But they were to some extent kind of, veiled by the kind of technical complexities of the administrative state. Now, because we have political momentum, and administrative agencies are trying to upend this long-standing kind of whatever you want to call it, neoliberal consensus that shaped all politics for a long time. It's people are noticing, right? There's no question that important things are being done. And so that understandably has caused, mobilization by conservatives. So, why are we here today? The background of all this, of course, is massive political polarization, which creates opportunities, but is also makes everything really difficult at the same time. So right now we're at this nexus of an incredibly conservative Supreme Court that has shown itself willing to upend, kind of all of the legal precedent foundational to the administrative state and kind of the New Deal era. We have that, but at the same time, we have kind of post-Occupy in the United States really increasing awareness and real public concern about the dramatically increased inequalities of economic and political power in the United States. Drastically higher public support for labor unions than a decade ago, and increases in real organizing. So that in tandem with with this incredible administrative leadership means there's folks are winning, and that has invited I think that's really scared some of the big companies of our time. And so I think one of the real to make it more concrete is once SpaceX once billionaires are scared of the power of the NLRB, they bring in the big guns. They bring in a kind of a different caliber of law firm that's used to kind of a no holds barred litigation and has an unlimited budget through which to wage that battle. And so I think, it's just a really interesting moment of we have some power and opportunity on the left to make a real change. And, conservatives are using the tools at their disposal to, in reaction, which includes a lot of money, and a Supreme Court that is proven itself ready and willing to kind of upend our, the consensus that came out of the New Deal.
Yeah, whether administrative law was ever boring or not, we can certainly agree that it certainly isn't boring now. And when you look at the attacks on the NLRB's constitutionality, it really is just one front reflecting a broader movement to dismantle administrative governance. I think you kind of hinted to this, Diana. We've seen this from corporate lawsuits, really against agencies' rulemaking and enforcement activities. It really isn't just unique to the NLRB, although again, this is kind of peak perhaps level of where the discourse currently is. Sabeel, kind of moving to you, what are some of the other attacks on the state that we're seeing, and how do these efforts fit into the broader really conservative movement's efforts to kneecap the ability of government to work for everyday people?
Yeah, thanks, Ali. And I'll reiterate what a pleasure it is to be in this conversation with my co-panelists and following the great remarks and incredible work of General Counsel Abruzzo and the team. So I think that's a great sort of zoom out, right? Because I think General Counsel Abruzzo and Hiba and Dana both also sort of mentioned in their remarks, this is one front in a broader array of fronts that are attacking, not just the NLRB, but also the Consumer Financial Protection Bureau, Federal Trade Commission, the Environmental Protection Agency, just to name a few. And you're seeing many different doctrinal attacks, so the SEC Jarchese case attacking agencies' authority to enforce their enforcement authorities in the first place, the so-called major questions doctrine emerging to kind of give the Supreme Court what I view as kind of a blank check to void any regulations they don't feel like supporting that particular day. There are a bunch of different lines of attack, but I think the broader tapestry that paints is, I think, a concerted effort to do exactly what Hiba, Diana, and General Counsel Abruzzo talked about already, which is undermine a key institution that is working on behalf of workers, communities of color, vulnerable communities who are the beneficiaries of legislation that Congress has passed, either recently or in decades past. So I really think we should, the lawyer in me, of course, wants to get into all the doctrinal stuff, but we should really view this as a larger power play. And I think we tend to think of this stuff as like big government versus small government. That's not the way I would think about this, because really what these attacks are about is removing government as a check on the private dominion and private power in the workplace, by monopolists, by folks who want to exercise discrimination against, people of color, LGBTQ folks, what have you. All of these different attacks are ways of removing the foundational checks and balances that we in previous generations have tried to put in place on behalf of the larger democratic public. And the last thing I'll say on this is that in a way, this is a kind of democracy nullification. So I do a lot of work on democracy and other parts of my work, and we're having a very important conversation about voter suppression and gerrymandering. That all is stuff that happens before an election. But what we're talking about today is also an attack on democracy after an election. You know, so if you lose an election and a statute passes that you don't like, well, great news, you can just then bypass all of the political process and use favorable judges and courts to forum shop and essentially rewrite statutes and rewrite the results of an election in a way that would never command majority support if you were to actually put it to the American public in a straightforward way.
And you know, something that kind of you bring to mind, Sabeel, is this, but don't we already know that there is a constitutional basis for administrative agencies and the NLRB specifically? Like, what, you know, in Hiba, maybe you could talk a little bit about this. Like, where is the NLRB's legal authority come from? Or, you know, as we kind of just contextualize all of these attacks that we're seeing, as we mentioned, across so many different fronts of the administrative state.
Okay, well, I'll try to be quick because I know we'll try to get to questions as well. And as General Counsel Abruzzo mentioned, nearly 90 years ago, which is unbelievable, the Supreme Court upheld the NLRA as constitutional. It was a Commerce Clause challenge, and the court, in kind of the switch in time that saved the nine, actually kind of reversed its Lochner precedent and started upholding as constitutional a range of federal legislation in the New Deal that then protected the National Labor Relations Act as the first in a line of federal statutes that Congress eventually upheld, including the Fair Labor Standards Act later on. So it's a Commerce Clause authority. So back then, you know, in the 1930s, the challenge was on the federal government's authority to supersede state and local labor regulation under common law. Now it's more directly about which institutions can better pressure private power, right? The courts or Congress and the executive branch, right? The political branches through the administrative state. And so the challenges are not Commerce Clause challenges. They're based on a series of challenges that have been devised by kind of impact litigation on the right to dismantle the administrative state, and that follow on from other cases that Sabeel was essentially mentioning with respect to kind of separation of powers challenges, challenges to the removal power of the president over principal officers in the administrative state, challenges under the Fifth and Seventh Amendments. So Article 3 challenges, really trying to reconfigure what role any agency might have in deciding public rights that Congress granted, the scope of those rights, the ability to remedy those rights in the context of the courts' relative authority to do so, and also kind of we're anticipating Article 1. There's actually an Amazon, in one of Amazon's challenges, there's a kind of Article 1 major questions doctrine challenge as well that may become more important to the extent, you know, the joint employer rule starts to get challenged and goes up to the Supreme Court. So there are different types of challenges. There's a wide range of them. Many of them may or may not be applicable or have the same impact on the NLRB as they might on the other agencies that have where parties have successfully challenged authority. And we can get into predictions, I think, later on about like what the likelihood both of the success of these challenges are, but also of what we think their effects will be on NLRB enforcement specifically. Any changes in NLRB enforcement that may actually where the NLRB actually may be relatively more protected in terms of impacts as compared to maybe other agencies. But yeah, happy to get into the details of some of those challenges in the Q&A if we have time.
Yeah, and I think you mentioned in terms of just the capricious nature, really, of where the Supreme Court is and where administrative law kind of sits at the moment. But as you kind of alluded to this, let's say if opponents were successful in hampering the efficacy of the NLRB and other administrative agencies, either by successfully challenging their constitutionality or by just even limiting their ability to function to begin with, what strategies can a pro-worker administration take to ensure that workers remain protected, and specifically that that some of these core functions are still at play in the federal government, and maybe also is there anything that even states have what's the role of states that they have to play in the occasion that again, opponents are successful, and I'll kind of open it up to all of you.
Um,
Well,
oh.
one. Well, go ahead. I didn't. I
Oh,
didn't
no, you go ahead.
Well, just a quick thing I'll throw in, because we have amazing labor law scholars on the Zoom, so I want to defer to them. But I mean, just as a general thing, I would also say I do think it's really important just like keep pushing the ball forward, right? And I think we heard this in General Counsel Abruzzo's remarks, right? There are many fronts on which agencies are trying to move and should continue to try to move on behalf of the public. In light of very strong, in my view, very strong sort of statutory authorities. So I think those are somewhat two different questions. Like what happens in court, knowing that we have a particular configuration, political configuration in some of these courts right now, that we have to sort of battle our way through. But I do think there's also just a kind of agencies need to kind of keep pressing forward. I would argue have very much a mandate to keep pressing forward, both from Congress and from the public, in terms of where the demands are and where the urgent public challenges are. And I think we're always in a contest over how to deal with the kind of backlash or counter mobilization, sort of to some of Diana's earlier points. So I think I would just sort of encourage for folks who are in it just to say, like, we should keep going, right? And this is going to take a longer arc to play.
Yeah, sorry, Hiba, you can bring us home. I guess I just wanted to weigh in to say that, there's a ton to be said, and many people like who are far more brilliant than I am on administrative law have said some of the kind of more, technically expert statecraft moves that can be done. Right. Many of the constitutional challenges are actually, if they were to prevail, they're actually easily remedied. And some of the other ones that are that we see in the queue or kind of like, broader attacks in the administrative state, we have folks talking about, how best to deal with the major questions doctrine. I come back to kind of the broader question of where society's at, and the reality of deep political polarization, and the fact that I think conservatives have a point that we do sometimes turn to the administrative state when when Congress isn't working, and that makes we need a functional government, and so there's great value in that. But certainly, I think many of us would prefer if we could get, an emphatic legislative mandate for some of these really important, policy advances. And so I think I always say that for social movements, for kind of public opinion, law, it can do one of two things. It can really emphasize the stakes of a conflict, right? And it does this, often through really powerful litigation stories. Litigation is storytelling. It can also make things really boring. To get back to my theme of like, what is the role of boringness here? And I think there is an extent to which, boring has a lot of definitions, but there's an extent to which parts of the administrative state have at times historically been about kind of limiting the audience of who engages with something, and also translating some really meaningful policy issues into kind of more technocratic language. And again, there's reasons. It's a really complex society we live in. These issues are hard. But I guess for me, one of the questions is, how can the administrative state be part of, as a part of the executive branch, how can it be part of kind of engaging with people, involving people in the process? I'm imagining an administrative agency like out there kissing babies. Like how can they be more involved in politics, the small p politics? And so I think, one of the things, General Counsel Abruzzo through being a rock star, Lena Kahn through being a rock star. I think that's part of it. But I think also increased attention to, how does the administrate become more participatory and empowering for everyday citizens is another really important piece of this.
Oh, okay. And I'll try to be quick. I mean, we're actually in a radical moment, which is really exciting. Many leading policymakers and scholars are reimagining both the constitutional authority and legislative agenda for more democratic and participatory forms of governance. And for the time being, right, we will still have an administrative state, and the role for the NLRB, if only because it has been such a successful mechanism for neutralizing labor militancy, for better or worse. But the question then becomes, like, what should that look like? Like, what should labor regulation look like within the administrative state, right? And for that, elections matter. Elections matter. So that, then it's just referring and echoing to what others have already said, PRO Act Plus reforms and other reforms to make these institutions more robust through legislative changes that override judicial rulings. But I think that there's a real role within the administrative state, to the extent we do have democratic administrations, to develop a deeper understanding of employer power within the administrative state, what its sources are, what tools we use to analyze it within the administrative state, what are the mechanisms for combating it through a whole of government approach that includes, but isn't limited to, labor law, and includes employment law, includes creating offices like an Office of Labor Policy that would be similar to the Office of Science and Technology Policy in the White House, that could establish a labor and development board to review and approve and monitor agency-wide enforcement that impacts worker power in a range of contexts that would include interagency coordination between the antitrust agencies, the consumer protection agencies, and the labor and employment agencies, and address what the impacts of monetary and fiscal policy are on what the agency's priorities would be, and how trade law and even criminal law can impact worker power. And I think as part of that kind of broader reassessment of strengthening worker power through the administrative state, one of the key roles I see for the executive and legislative branches outside the courts is to improve and create and strengthen labor market institutions that empower workers to assert countervailing leverage against strong employers through increasing their voice, which is really important for the board, but also their exit options, right? Which means creating things like a federal job guarantee, something I wrote a Roosevelt brief on, creating wage boards, place-based wage boards to lift, workers who are most vulnerable in communities that are rural and distressed from the potential for co-optation by firms that can take advantage of labor laws, protections for dismantling unionized workforces and relocating in areas of the country where labor costs are lower, but also a really important role for the federal government to empower local institutions like worker cooperatives and worker-owned firms in ways that strengthen worker power. So I think we should be and can be really creative outside the courts as well.
Yeah, Hiba, I think you're absolutely right in terms of it's not just about enforcing collective bargaining rights, but there is really this broad spectrum of different facets and dynamics that ultimately impact worker power and certainly labor markets. I think something that you all touched about was this idea of it'd be really nice if we had a legislative mandate that ... What can you all say about what other branches of government can do to really stem the anti-administrative movement?
Yeah, I mean, just to start, and I mean, I do think a big piece of this is legislation. I think we had some burst of legislative activity, a couple of years ago, which kind of opened the doors on a whole bunch of other opportunities. I think we're starting to see, both some of the ideas for worker power that Hiba was mentioning, but also some important ideas around corporate power, right? Sort of a draft legislation percolating around on, kind of reviving anti-monopoly authorities, the future of the child tax credit and sort of other kinds of like exit options, sort of to your point, Hiba. So I do think there's like a general, like, keep pressing on what legislative opportunities they are. But I also think this is part of why a long-term agenda on worker power and corporate power is also part of a democracy agenda, and vice versa, right? You don't get very far without also contemplating things like the Freedom to Vote Act, like even more bigger picture, blue sky, far down the road, ideas like how we might have more proportional representation in Congress, for example. That's much further down the road, but I do think there's sort of a longer arc here of thinking about legislative changes to how our government operates more generally, and sort of taking advantage of those legislative moments. But those are themselves products of social movement organizing, sort of some of what Diana was saying. I think policymakers are more often than not followers rather of a broader like political press than instigators, though you have some who are also instigators, which is useful. But I think in general, these breakthroughs happen when you have a convergence of bottom-up movement power and on the shelf, ready to go, worked out ideas for regulatory or legislative action.
Yeah, and one of the impacts of these Article 2 challenges, in part, could have the perverse effect of strengthening the unitary executive, right? Which in the context of democratic administrations could mean a lot of executive power to do all sorts of things through the agencies, using tools like executive orders, task forces, right? Broader interagency coordination mechanisms, really using the spending authority to enable forms of worker protections through procurement, project labor agreements, community benefits agreements, and conditioning, fiscal policy and grants on things like that, facilitating labor standards and enforcement mechanisms through industrial policy, like President Biden has done. And also, I think there's a lot of room, and we can get into this maybe in the Q&A, for state and local efforts, which is a huge part of this picture that labor scholars are focusing on, but also the movement organizers have been focusing on legislative reforms in both labor, but also antitrust law at the state level, to enhance, to create broader protections for collective bargaining, for worker organizing efforts, for sectoral bargaining laws, for non-compete bans, right? Regulation of other forms of employment contracting that are abusive towards workers.
And just to, I have been looking at the Q&A, and you have all been doing an awesome job at addressing a lot of the questions there. And so I'm kind of paraphrasing here and there. One thing that I also kind of, as we have about 5 minutes left or so, I'm curious to hear from each of you. We know what the current state of administrative law is. We know the current state of the court. Looking forward, what do you believe is the future of the NLRB and just of administrative law in the United States? And what do you think we need? And we keep talking about legislative mandate. Maybe that's what it is. Maybe it's constitutional reforms. What else is needed to ensure that the NLRB and other kind of administrative agencies that are doing such amazing work, exist and continue to be effective?
I'll start. I mean, I don't know that I have I don't have the answers, but I think one interesting question specifically for the NLRB is, the NLRB has always been to some extent a little bit anomalous relative to other agencies, in part because of its history, as Hiba's scholarship has addressed, of getting rid of the agency's authority to actually hire economists and other kinds of experts who might do the empirical work that so many other agencies kind of rely on, and that is so much, to some extent more the model of what an administrative agency should do. In earlier critiques of the NLRB, some of the ones that I was pointing to earlier, there was this sense of, the NLRB relies too much on lawyers and does too much rights balancing, and really should try to develop a kind of an expert empirical approach to some pressing questions. And I think there's really, that's absolutely an important point. The fact that we haven't had an NLRB kind of like direct vision of economics, such that, the Department of Treasury just issued that report saying unions are good for the economy. It would be fantastic if we were getting that kind of research out of the agency that knows the most about unions. That said, what's so interesting about some of the current attacks is that some of the things that the NLRB has long done, such as doing things largely through kind of quasi-judicial procedures, mean that they're less vulnerable to some of the attacks. And that they're, and that they have, there's now arguments like we need, if we want to have, Blake Emerson has the piece about, needing to have more kind of moral judgment through administrative agencies. And, his argument was we could, who's good at that? Lawyers. And so the board has always, so I think there's this real kind of tension in what's the best direction for the board, and perhaps, some balance of the two is actually the dream, to be able to do both. On the piece though of, should administrative agencies be talking about value, some of my research talks about the extent to which the law has purposely minimized some of the really important kind of, normative underpinnings of what labor law does: industrial democracy, worker freedom. And so I'm really excited about the extent to which that kind of piece of justification and mandate for the board's authority can become more a part of the conversation.
Yeah. Oh, no, go ahead.
No, go ahead, Hiba. I'll go after you. Sorry.
Yeah, I mean, I'll be really brief because I think we have 1 minute. But one of the things that I think is really important, and Diana mentioned this too, is the expertise of the agency and strengthening the expertise of the agency. We're in a moment where, for example, I know the antitrust agencies, because I was in one, are really dramatically changing not only how they assess anti-competitive conduct and corporate consolidation and dominance, but also how they're analyzing the effects of firm power or corporate power, and hiring a broader set of economists and thinking, strategically about how we can actually document and trace what the impacts of corporate power are. We don't really have as much of it. Well, we have some of that in the Department of Labor. We don't have any of that in the NLRB. And so one of the tasks, as General Counsel Abruzzo stated, of the NLRA is to equalize bargaining power between workers and employers. And how can we substantively know where there's unequal bargaining power? I think one of the roles of the board is to actually broadcast that and explain that as its public function. The circumstances where it's enforcing are circumstances where it is finding unequal bargaining power, and what that looks like, how workers can recognize it, and how it can actually use its authority to remedy it in concrete ways through an expertise-based analysis. Some of that, of course, involves a congressional repeal of the ban on hiring economists. But I think there are other ways that you can use, the board's relationship with other administrative agencies to explain and broadcast this as part of the public good function that it performs in the context of, the dynamics of class power.
Great. And Sabeel, last thoughts for you, please.
Great. Very quickly, this is all great. I'll just add 2 things that we haven't mentioned yet. One is I would be really interested in what a blue sky progressive vision for a future administrative state looks like, as in, like, what is our 2024 and beyond version of the APA? What is our 2024 and beyond version of the whole, like, creation of the New Deal set of agencies? It's been a while since the CFPB was created, but, the structure of exploitation and extraction and power imbalances in our society is very different now than it was even 15 years ago. And we should really think blue sky about what kinds of administrative apparatuses we need to build the kind of democracy we want. And then the last thing is court reform has got to be a part of this. So whether it's a separate piece or whether it's provisions in a worker power legislation about jurisdiction and about a congressional override when the court mistakenly interprets a statute that may or may not have been written, some time ago. There are a million things that we should do, but I think that has to be top of the list.
Great. Thank you all, Hiba, Diana, Sabeel, and of course, thank you to General Counsel Abruzzo for her remarks. It's been a great pleasure speaking with you all today. I do, if you're out there, please check out the Roosevelt Institute as well as the great work of all of our different panelists. Thank you so much for joining us today. And I think if it's nothing else, we've settled today that administrative law is certainly very busy today than it ever has been. So thank you all.
Thank you, Ali. Thank you, everyone.
Thank you.
Thank you.